you, Mr. Connor. Mr. Ware.
Chairman Cole, Ranking Member Hatch, Senator Martinez, members of the committees, thank you for having me here today. My name is Stephen Ware. I'm a professor of law at the University of Kansas. I speak to you today not on behalf of my university, but as an individual scholar who specializes in arbitration law. I've written 2 books on the subject and 20 arbitration articles in scholarly journals. Within my field of arbitration law, I have focused on the arbitration of disputes involving ordinary individuals, and it's safe to say that for the last 15 years, the bulk of my professional life has been devoted to studying the law, economics, and policy of such arbitration. It's based on this experience that I oppose S 2838 because I believe it will tend to harm those it aims to protect, that is, nursing home residents and their families. I have 3 points I want to make about arbitration. The first point, which Senator Cole alluded to, is that arbitration, to the extent we have reliable empirical evidence comparing arbitration and litigation, arbitration does tend to be a quicker, cheaper method of dispute resolution. So the savings that Mr. Hatch, Senator Hatch alluded to are backed up by empirical data. And that leads me to my second point, which is that advocates of this bill often praise arbitration and allude to those benefits of arbitration and say that, well, we're going to keep arbitration, we like arbitration, all this bill will do is ban pre-dispute arbitration agreements. That, however, sets up a false choice. If you ban pre-dispute arbitration agreements, you effectively end virtually all arbitration of this sort of dispute. And that's because parties rarely enter into post-dispute arbitration agreements. The vast majority of arbitration arises out of pre-dispute arbitration agreements. The fact that parties rarely enter into post-dispute arbitration agreements does not reflect badly on arbitration. What it reflects on is the perspective the disputing parties have after a dispute arises. At that time, parties and their lawyers can assess a case, and they try to maneuver into a forum that advances the self-interest of that side of the case. In other words, one party may be attracted to litigation precisely because it's not as fast, it's not as cheap as arbitration. That can give a strategic advantage to that side. So we rarely see post-dispute arbitration agreements. Enacting a bill like this, I expect, will virtually eliminate arbitration of these sorts of disputes. And that then brings me to my third point, which is the fairness of arbitration. I think it's important to avoid generalizing here because there's a wide variety of arbitration agreements out there and a wide variety of things happen in arbitration. And here's where I really believe we have a sensible system in the law right now where we have courts under the Federal Arbitration Act as it stands now, we have courts refusing to enforce arbitration agreements that are unfair, that would lead to a unfair arbitration process. So as Senator Martinez says, we all want to hold nursing homes accountable for their negligence. Certainly the sort of atrocious care Mr. Kirk describes, we all want to hold nursing homes accountable for that sort of care. The question is, will arbitration do that? And sometimes the answer is yes, sometimes the answer is no. It depends on the particular arbitration agreement, the particular arbitrators involved. So what we have now is a very sensible system in the law where courts decide on a case-by-case basis which arbitration agreements to enforce and which ones are unfair and should not be enforced. I think that's a better system, case-by-case adjudication of these fact-intensive issues, than legislation which would paint with a broad brush and would be over-inclusive. Thank you very much.
Thank you, Mr. Ware. Question for you, Mr. Connor. Ms. Reichsfield says that Mr. Kurtz's case, as we heard about it today, is a, quote, exception and but not the rule. I'd ask you how prevalent are arbitration agreements and admissions contracts, and how common are stories like Mr. Kurtz that we heard today.
Mr. Kirk's story is all too common.